This video examines the judicial review of the Combating Hate Act, formerly Bill C-9, which presents a legal challenge to federal legislation. The facial challenge is based on the constitutional rule of law. The Canadian Bill of Rights of 1960 established common law and binding case law. This judicial review challenges the legal validity of the act itself. The clear legal position is that a judicial review of the Combating Hate Act is legally available and properly grounded as a facial challenge to enacted federal legislation. This is supported by the constitutional preamble, the Canadian Bill of Rights, common law protections, and binding case law. Crucially, no prior enforcement is required for this challenge. The constitutional foundation, rooted in the Constitution Act 1867, states that Canada is founded upon the supremacy of God and the rule of law. The rule of law requires non-arbitrary state action, clear legal standards, and defined limits on power. This foundation incorporates British constitutional traditions, natural justice, and the protection of civil liberties. Key rule of law authorities include Roncarelli v. Duplessis, 1959, establishing that public authority cannot be exercised arbitrarily, and Entick v. Carrington, 1765, requiring state interference to be clearly authorized by law. These historical principles are essential for modern constitutional legality. The Canadian Bill of Rights, 1960, applies to all federal legislation. Section 1 recognizes fundamental freedoms such as religion, speech, assembly, association, and the press. Section 1A protects life, liberty, security of the person, enjoyment of property, and due process of law. Section 2 of the Bill of Rights requires federal laws to be interpreted, so they do not infringe protected rights. If legislation cannot be interpreted consistently with these protections, the law becomes inoperative. Authorso v. Canada, 2003, confirms the operative force of the Canadian Bill of Rights. The judicial review relies on controlling case law, including precedents such as Roncarelli v. Duplessis, Entick v. Carrington, and Authorso v. Canada. Other key cases include Campbell Motors Limited v. Gordon and Canada, AGV Power. Legislation may be challenged on its face due to facial invalidity. Courts may invalidate laws if they are vague or overbroad, or if they authorize arbitrary enforcement. Importantly, no prosecution is required before a review of the law's validity can take place. The Act introduces vagueness and uncertainty, as key terms like hatred, promotion, and intimidation lack clear legal definitions. These vague standards allow for arbitrary enforcement and violate due process protections. Facial invalidity allows legislation to be challenged on its face. Courts may invalidate laws if they are vague, overbroad, or authorize arbitrary enforcement. Again, no prior prosecution is necessary before a judicial review can occur. The Act creates an immediate harm, known as a, quote, chilling effect, resulting in self-censorship, the suppression of religious teaching, and the restriction of public speech, assembly, and publication. Legal risk arises immediately upon the Act's enactment. Regarding the liability of the state, Roncarelli v. Duplessis, 1959, established that officials are personally liable for the abuse of power. Furthermore, Canada, AGV Power, 2024, indicates the Crown may be liable for unconstitutional legislation. Thus, decision-makers face potential legal consequences. The grounds for judicial review include the Act violating the Canadian Bill of Rights, failing due process requirements, allowing arbitrary enforcement, suppressing lawful expression, and constituting oppressive or unreasonable legislation. Available remedies include the court declaring provisions inoperative, issuing an injunction preventing enforcement, awarding damages, and recognizing personal liability. These remedies are essential to restore constitutional legality. The material before the court supporting the review includes the affidavit of the applicant, the text of Bill C-9, the legislative record, and relevant legal authorities. The relief sought includes a declaration that the provisions are inoperative and an order prohibiting their enforcement. We also seek an interim and interlocutory injunction, damages against the Crown, and any further relief the court deems just. The material before the court includes supporting documentation such as the affidavit of the applicant, the text of Bill C-9, the legislative record, and relevant legal authorities. The legal basis for this challenge is grounded in the Federal Courts Act, the Canadian Bill of Rights of 1960, the Constitution Act 1867, and common law authorities. Together, these establish the foundation for judicial review. Our final legal position is that there is a clear legal basis to challenge the Combating Hate Act. Canadian law confirms that civil liberties are protected, arbitrary interference is unlawful, and courts can invalidate improper legislation, holding officials accountable. The final message is that judicial review is crucial for maintaining the rule of law, protecting civil liberties, and ensuring government authority remains lawful. This is grounded in federal statute, constitutional principles, and common law tradition.